Parviz Ravi, attorney at law, have been practicing for over 20 years. Our office is located by San Francisco Airport, specializing in employment law. Today's topic, severance package and employee rights in California, part 2. A severance package is a payment by an employer to an employee at the time of employee's termination. It is usually given in exchange for a written promise from the employee that they will not file a lawsuit against the employer. This written promise is usually called a severance agreement. In general, severance agreements are legally valid and will be upheld by courts if the agreement is entered into voluntarily and the terms are legal. This is true even if it seems like that the employer is getting a better deal. While it is good that your employer is offering you some money, it's also important to understand that by signing the severance package, you're waiving important legal rights that would entitle you to even more money. Consider the following tips if planning to sign severance package. If you feel your termination was unfair, you should be cautious about signing severance package. If you're being laid off or quitting your job due to harassment, retaliation, or some other employment law violations, you should consider consulting an employment lawyer about any legal claims you have before signing the severance agreement. If the severance agreement contains a non-compete clause or non-disclosure clause, you should consider not signing the agreement, although it may be questionable whether these clauses are enforceable. Agreeing to a non-compete and non-disclosure clause could significantly limit the work you perform for your next employer and therefore make searching for another job much more difficult. If the severance agreement involves admissions of fault, you should consider not signing the agreement. This is especially true if you are admitting or acknowledging workplace problems that you did not commit or were not your fault. These admissions to fault could harm your future employment prospective and job benefits. Do not sign the severance agreement if the language in the severance agreement is confusing, broad, or vague. It is important that you understand exactly which rights you're waiving and which obligations you are undertaking. It is usually unwise to sign a severance agreement without fully understanding its terms. If you witness a wrongdoing in the workplace or believe your rights were violated, you should be cautious about signing the severance agreement. No matter what your employer tells you, you are not required to sign a severance agreement. You always have the right to consult with a lawyer, even if you are sure that you understand the terms. If a severance agreement requires you to give up any rights to sue, you should consider consulting with an attorney before signing. An attorney can explain to you whether the severance agreement is legal, and if so, what you will be giving up. Remember, your rights as an employee are protected by law, and you have the means to take action if your employers failed to comply with the regulations. So stay informed, know your rights, and advocate for fair treatment in the workplace. If you have any questions on this topic, please contact my office for free consultation. Please be sure to like and subscribe and turn on your notification.